Picture a rural Alabama clinic. It's like 6 minutes past midnight. The spring beepers are just incredibly loud in the dark, and an old Toyota SUV rolls up to the back door with its headlights totally killed.
Right, setting that covert scene.
Exactly.
Yeah.
And inside that clinic is Dr. Bria Gaines, a local physician. Outside, there's a terrified 13-year-old girl named Nova, accompanied only by her school nurse, and the child is pregnant.
Oh, wow.
Yeah. She's profoundly desperate, threatening to use a coat hanger on herself if she isn't helped immediately.
Which is just, I mean, a horrific situation for anyone, let alone a 13-year-old.
Right, and under state law, the doctor's obligation is to report the child to the authorities. That basically forces the state apparatus to ensure this 13-year-old carries the pregnancy to term.
But she doesn't do that, does she?
No. Instead, the doctor makes a choice to perform an abortion, intentionally committing a Class A felony to protect the child sitting right in front of her.
And the moment that procedure is finished, a bomb basically goes off. It just shatters the legal, political, and social foundations of that entire community.
Welcome to this deep dive, everyone. Our mission today is to immerse you in this gripping legal thriller, Judge Stone, co-authored by Viola Davis and James Patterson.
It's such a heavy, fascinating book.
It really is. We are going to unpack precisely how this narrative explores the intense, high-stakes friction between the strict textual letter of the law and the broader, well, the often murkier spirit of justice.
Right, and we'll be looking at how rural county politics, deeply entrenched historical trauma, and just impossible moral dilemmas turn the supposedly precise instrument of the courtroom into a literal battlefield.
But before we go any further, I think we really need to establish the parameters of our discussion for you, the listener.
Yeah, absolutely crucial point here. The central conflict in Judge Stone is driven by the Alabama Human Life Protection Act and the criminalization of abortion. And you know, this is an intensely polarized, highly charged political and social reality. So our role here today is strictly analytical.
We are not taking a side on this issue.
Exactly. We are not endorsing, nor are we condemning the laws, the political viewpoints, or the actions depicted in this novel.
We're basically acting as your impartial guides through the fictional universe that Davis and Patterson have constructed.
We just want to analyze the plot, the character dynamics, and most importantly, the complex legal mechanics as they play out within the confines of Bullitt County, Alabama.
Right. We want to understand how the system functions, how it gets manipulated, and how it's ultimately tested by the people trapped inside it.
So to understand the weight of this impending trial, we first have to understand the arbiter of that trial. The entire narrative hinges on the woman actually wielding the gavel.
Judge Mary Stone.
Yes. She is a 50-year-old black woman serving as the circuit judge in Bullitt County, which is this rural jurisdiction in Alabama's Black Belt.
And it's tiny, right? I mean, the county seat of Union Springs has a population of just over 3,000.
Barely a dot on the map, yeah. And the juxtaposition of her life is just fascinating. The authors don't establish her authority by showing her in some sterile metropolitan high-rise.
Right, she's not in a glass tower in Atlanta or something.
Exactly. They ground her deeply in the dirt of her jurisdiction. She lives on a 60-acre ancestral farm.
And her mornings start at like 4:30 a.m. She's out there in rubber chore boots, raising high-breed Charolais beef cattle.
Yeah, and tending to a pregnant quarter horse named Tornado.
Oh, and battling that highly aggressive rooster. What was his name?
Foghorn Leghorn.
Right. I mean, she's literally fighting a rooster before she goes to court to fight lawyers.
It's a great detail. But that agricultural grounding, it serves a really specific narrative and thematic purpose.
How so?
Well, raising Charolais cattle, for instance, requires meticulous attention to lineage, environment, physical care. It establishes Judge Stone as someone deeply invested in the long-term stewardship of her environment.
So she's not just clocking in and out.
No, not at all. When she transitions from the physical labor of the farm to the intellectual labor of the courtroom, she carries that exact same methodology. She isn't some imported legal technocrat. She's a product of this specific geography.
And the geography of where she presides is just incredibly heavy with history.
Oh, massively.
She sits on the bench in the Bullitt County Courthouse, which is this 1871 Empire-style brick structure. It's on the National Register of Historic Places.
Objectively beautiful building.
Right, it's gorgeous. But, you know, the architectural history of the South is never just about aesthetics. This building was constructed right during Reconstruction.
And for nearly a century after its foundation was laid, the very institution it housed actively suppressed the people of her community.
Yeah, the authors really don't let the reader forget that physical and historical irony. Every time Judge Stone climbs that double-curved staircase to her chambers, she's occupying a space where her ancestors were violently disenfranchised.
The text actually notes that her great-grandfathers were barred from voting by the Ku Klux Klan.
Wow.
Yeah. One grandfather was sidelined by poll taxes, another by rigged literacy tests. The women in her family were legally locked out of the democratic process in that very building until, the Voting Rights Act of 1965.
Which has to fundamentally alter how she views her position, right? I mean, she isn't just an employee of the state.
Exactly. She is the literal manifestation of a generational struggle to claim space within that state.
And we see this profound local connection in her interactions with the courthouse staff, too, like Aurora Freeman, the 70-something custodian.
Oh, I love Aurora. She still calls her Judge Mary because Aurora used to work in the lunchroom when Mary was a child at Union Springs Elementary.
Right. There's a familiarity there that grounds the judge, but it also highlights the intense isolation of her role.
That isolation is a critical component of her character profile. Think about it. She holds unilateral power over the liberty of the people she grew up around.
Yeah, that's heavy.
It is. And despite her fierce competence, she graduated at the top of her class at the University of Alabama Law School, became one of the first black women elected to the circuit bench in the state. Despite all of that, she wrestles with persistent imposter syndrome.
I really want to examine that imposter syndrome, actually, because on the surface, it feels totally counterintuitive.
How do you mean?
Well, you have a woman wielding immense institutional power. She can strip away a person's freedom for the rest of their natural life with a single signature. Why would someone with that level of codified authority still hear an internal voice questioning her legitimacy?
It's a really good question, and honestly, it's a highly accurate psychological profile when you view it through the lens of intersectionality within the American legal system.
Okay, unpack that a bit.
Her power is institutional, sure, but the institution itself was historically designed to exclude her demographic entirely. Her imposter syndrome isn't rooted in a lack of legal acumen. It is the psychological tax of occupying a historically hostile space.
Oh, that makes sense.
Right. She's hyper-aware that many defendants and even her colleagues in the local government view her presence on the bench as an aberration, like an affirmative action concession rather than a merited appointment.
So she basically operates under the assumption that she has to be flawless because the system won't afford her the grace of human error.
Exactly. Any mistake won't be attributed to a simple misjudgment. It will be weaponized against her race and her gender.
And we really see how she armor plates herself against this scrutiny in her daily docket. Take the sentencing of Farrell Gray.
Oh, the Farrell Gray case is a masterclass in judicial temperament under extreme duress.
Totally. So Gray is a white supremacist who murdered an elderly couple during a burglary. The jury has recommended the death penalty.
But right before the sentencing hearing, Gray sends this violently racist, profane letter directly to Judge Stone's chambers.
It's not just standard legal maneuvering, right? It's a direct personal intimidation tactic. Uses slurs, attacks her appearance, denigrates her qualifications, and then takes it into this incredibly bizarre, terrifying territory.
Yeah, he claims he has made a literal blood pact with Satan.
Wait, Satan? Like literally the devil?
Literally. And he promises that if she sentences him to death, demonic forces will ensure she suffers a gruesome, agonizing demise.
That is wild. But I mean, what's the actual goal of a letter like that?
The goal is to force a recusal or provoke an emotional reaction that could be used as grounds for an appeal. If the judge loses her temper on the record, the defense can argue she was prejudiced.
Oh, so it's a trap.
The total trap. But look at the mechanics of her response. In the courtroom, Gray acts out, he flips her the bird, he explicitly demands a new judge, citing his racial animus toward her.
And she entirely diffuses the bomb using strictly legal mechanisms.
Yeah.
She doesn't yell. She doesn't take the bait.
Not even a little bit. She recites an Alabama appellate decision completely from memory, establishing the precedent that a defendant cannot successfully go judge shopping simply by hurling abuse at the presiding judge.
Basically saying you can't manufacture a conflict of interest through your own bad behavior.
Precisely. She calmly denies his motion and sentences him to life in prison without the possibility of parole. She completely neutralizes his attempt to control the room.
She treats the law as an impenetrable shield.
Huh.
But she also uses the gavel as a highly precise weapon to protect the vulnerable, like with the protection from abuse docket.
Which is a staple of family and circuit courts. It's grueling work.
Yeah, we see a woman named Ada King come into the courtroom with her eyes swollen shut and her lips split, seeking an ex parte protective order against her fiancé, Leroy Stewart.
Now, ex parte meaning the order can be granted by the judge based on the victim's testimony without the abuser needing to be present to argue against it, right?
Yes, exactly, because the immediate physical danger is just too high.
Right, it's an emergency intervention.
Yeah.
But in this scene, Leroy Stewart actually has the audacity to just be in the courtroom.
Yeah, he attempts to downplay the violence, telling the judge that Ada is just mad right now, and basically implying the court shouldn't intervene in a domestic dispute.
And Judge Stone's reaction is swift and absolute. She berates him, cutting off his rationalizations, and explicitly states that he has zero legal right to put his hands on her. She issues the protective order on the spot.
If we think about the archetype of the frontier sheriff, I feel like Judge Stone embodies that role for Bullitt County.
That's a great analogy.
She is the lone authority figure maintaining order in a rugged, isolated jurisdiction, and her weapon is her absolute mastery of statutory law.
But that equilibrium she maintains, balancing the historical weight of the county, the grueling nature of her dockets, the intense scrutiny, it's a very delicate high-tension wire act.
And that brings us to the moment the wire just snaps. The narrative shifts from the steady rhythm of a local courthouse to a full-blown constitutional crisis, all triggered by the events at Dr. Bria Gaines's clinic.
Right. Let's look at the mechanics of the impossible choice Dr. Gaines is presented with. We have 13-year-old Nova Jones and her school nurse, Cochetta Bass, arriving at midnight.
And Dr. Gaines immediately registers that the situation is incredibly precarious because a crucial figure is missing. Nova's mother, Starla Jones.
The absence of the parent in a pediatric medical setting immediately elevates the legal risk for any doctor.
Yeah, and when Dr. Gaines asks about the mother, the nurse explains the terrifying reality of Nova's home life. Nova began menstruating at age 9, at which point her mother handed her a sanitary pad and explicitly threatened to throw her out onto the street if she ever came home pregnant.
So Nova is living in absolute terror of her primary caregiver.
Yes. The desperation is so acute that Nova has threatened to perform a coat hanger abortion on herself if she doesn't get clinical help.
And the nurse, who is so anxious about this clandestine meeting that she has been physically ill all day, tells the doctor that she simply couldn't live with herself, knowing this child might bleed to death in a bathroom because she was turned away.
It's just a heartbreaking scenario. As a physician, Dr. Gaines asks the standard, legally necessary diagnostic question, who is the father?
Because the answer dictates whether the clinic is dealing with a consensual teenage pregnancy or statutory rape and incest.
Right, but Nova absolutely refuses to name the partner. She just shuts down completely.
And this creates a suffocating legal trap for the medical professionals. Both Nurse Bass and Dr. Gaines are classified by state law as mandated reporters.
Could you define the mechanics of mandated reporter laws for us?
Sure. These are statutes that legally require certain professionals, like doctors, nurses, teachers, social workers, to immediately report suspected child abuse, neglect, or statutory rape to the state's Department of Human Resources or local law enforcement.
And what happens if they don't?
Well, failure to report is in itself a criminal offense that can cost a professional their license and even result in jail time.
So, because Nova is a 13-year-old pregnant minor who refuses to identify the partner, the law views this as a presumed case of statutory abuse.
Exactly. The state compels the doctor to pick up the phone and call the authorities.
But if Dr. Gaines makes that call, what is the practical outcome for the patient sitting right there on the exam table?
That's the crux of it. Once the state is notified, the machinery of the government takes jurisdiction over the child's welfare. Under the parameters of the Alabama Human Life Protection Act, which criminalizes abortion in almost all circumstances, the state would intervene not to provide the procedure, but to effectively mandate that the 13-year-old carry the pregnancy to term.
Wow.
Yeah. The state enforces the birth.
So we are really looking at a modern clinical application of the trolley problem.
Oh, absolutely.
Dr. Gaines has taken the Hippocratic Oath to do no harm and to prioritize the well-being of her patient. She assesses a 13-year-old child who is threatening horrific self-mutilation and who is terrified of becoming homeless.
And the doctor determines that the immediate psychological and physical devastation of forced birth on this specific child outweighs the mandate of the state statute.
She chooses to pull the lever. She performs the abortion. By prioritizing the patient's immediate survival over the text of the law, she willfully and intentionally commits a Class A felony.
But legally speaking, and I know morally it's complex, but legally, wasn't her action entirely indefensible under the statute as written?
Yes, the law, as written, is entirely binary. It does not account for the moral panic of a physician or the psychological terror of a middle schooler.
Right.
The statute dictates that performing an abortion is a felony punishable by up to 99 years in a state penitentiary.
99 years for a doctor trying to save a patient.
Yes, with the only exception being a severe, imminent physical risk to the life of the mother.
And this is exactly where the strict textualist application of the law collides with human reality. The defense will eventually attempt to argue that Nova's threat of self-harm constituted a severe health risk.
But from a prosecutorial standpoint, the law is designed to be blind to the doctor's empathy. Dr. Gaines committed the act, therefore she must face the full weight of the state.
Because the crime is so legally definitive under the statute, yet so morally fraught, it instantly transforms from a local tragedy into a statewide political powder keg.
Yeah, high-profile cases act like a gravitational pull for ambitious political actors, and they swarm Judge Stone's jurisdiction almost immediately.
The ecosystem of pressure that forms around this trial is just a masterclass in understanding how the justice system is inextricably linked to political optics. Let's analyze the antagonists here, starting at the local level with District Attorney Robert Reeves.
Right, Reeves is the archetype of entrenched local power. He is arrogant, dismissive, and views his office as, like, his own personal fiefdom.
When he enters Judge Stone's courtroom, he is perpetually late, unapologetic, and barely even acknowledges her authority.
Because for Reeves, the indictment of Dr. Bria Gaines isn't about the moral complexities of a 13-year-old's pregnancy. It is a career-defining slam dunk. He wants the political capital of being the prosecutor who locked up the abortion doctor.
But the state-level apparatus realizes that a case of this magnitude cannot be left entirely to a local DA. The optics are just too valuable.
So the State Attorney General's office deploys Assistant Attorney General Eleanor Lindquist to co-prosecute.
And Lindquist is a highly polished, media-savvy attorney who arrives in rural Bullitt County in impeccably tailored navy blue suits. She represents the polished machinery of state power stepping in to actively manage the narrative.
The pressure really escalates in the courtroom to the judge's private chambers, too. Judge Stone receives a phone call that represents a staggering breach of judicial independence.
Oh, this scene is so tense.
The governor of Alabama, Burt Lamar, and the state attorney general, Dick Winston, call her on speakerphone.
We really need to dissect the ethical mechanics of this phone call. In the legal profession, ex parte communications, where one side or interested party communicates with the judge without the other side present, are strictly forbidden.
Especially regarding a pending case, right?
Yeah, exactly. For the executive branch, the governor and the chief law enforcement officer, the AG, to directly contact a presiding judge about an active criminal docket is an overt, massive attempt to subvert the separation of powers.
And the governor attempts to wrap the coercion in this veneer of folksy charm. He tells Mary that everyone gives her 5 gold stars, utilizing this incredibly patronizing, infantilizing tone.
It's gross, but the objective is clear. They want her to recuse herself from State v. Gaines so the trial can be relocated to a friendlier, more controlled venue like Montgomery or Birmingham.
They want the trial out of the Black Belt.
Precisely. They recognize that Judge Stone is fiercely independent, and they fear she might rule strictly on the law rather than bending to the political winds of the state capital.
The AG wants the case in a jurisdiction where he can tightly manage the media access, the jury pool, and the presiding judge.
And when she refuses their friendly suggestion to step down, maintaining that she is fully capable of presiding impartially, well, the mask just slips.
Yeah, Attorney General Winston drops the civility entirely. He threatens her political survival. He assures her that Dr. Gaines will be convicted, that the jury will hand down a 20-year sentence, and that if Mary stands in the way, the ensuing political fallout will permanently destroy her career.
When the direct institutional pressure fails to force a recusal, the attacks become asymmetrical and deeply personal.
The political machinery understands that if they cannot control the judge's rulings, they must destroy her credibility in the eyes of the public. That way, any ruling she makes can be dismissed as the work of a biased radical activist.
This manifests in a vicious tabloid smear campaign. A story is leaked to the press claiming that Judge Stone has a hidden gay agenda that will bias her handling of the abortion trial.
And the evidence for this agenda, the fact that she is a 50-year-old unmarried woman who regularly has dinner with her best friend, who happens to be a lesbian activist from Montgomery.
It's just character assassination by insinuation. They're leveraging conservative cultural anxieties in her district to undermine her moral authority. If the public views her as morally suspect, her judicial decisions lose their inherent legitimacy.
But the most insidious attack is aimed not at her reputation, but at her generational wealth and physical sanctuary.
The land grab.
Yes, a collections attorney named Arch Pierce sends her a certified letter initiating a land grab against her 60-acre ancestral farm.
Pierce claims he represents a client, Caleb Wilton, who recently purchased an heir's interest in the farm from a distant, previously unknown relative named Abraham Stone.
And Pierce is demanding the entire farm be sold at public auction so his client can monetize this fractional interest.
The inclusion of this subplot by the authors is a brilliant, devastating critique of property law in the American South, specifically regarding what's called heirs property.
Right. We have to explain how this mechanism functions, because it has been historically weaponized to strip black families of their land. Let's dive into the mechanics of heirs property. How does a shady attorney use a distant relative to force the sale of an entire 60-acre farm?
Okay, so when a landowner dies without a will, which is called dying intestate, the property is inherited by their descendants as tenants in common. Over several generations, a single piece of land might have dozens or even hundreds of fractional owners.
Meaning they all hold a legal interest in the entire property rather than specific subdivided parcels.
Exactly. So Mary's great-grandfather passes the land down, and over a century, the family tree branches out, creating multiple fractional owners.
Even if Mary is the only one actually living on and maintaining the land.
Correct. The vulnerability of this system is that any single fractional owner, no matter how small their percentage, can legally force a partition sale of the entire property.
It's terrifying.
It is. Predatory developers or bad actors like Arch Pierce will track down a distant, disconnected heir, someone who has never even seen the farm, like this Abraham Stone, and buy their tiny fraction of ownership for pennies.
And once Pierce's client owns that fraction, they step into the shoes of a tenant in common. They then file a lawsuit demanding the property be sold at auction to liquidate their share.
And because the family living on the land usually can't afford to buy out the entire property at market value during a forced auction, the developer swoops in, buys the ancestral land at a fraction of its true value, and evicts the family.
It's entirely legal, and it has been used to systematically dispossess Black Americans of millions of acres of agricultural land over the last century.
Arch Pierce sees a vulnerable, highly distracted judge engaged in a career-ending trial, and he assumes she won't have the bandwidth to fight a complex property dispute.
But Mary Stone refuses to be a victim of a paper hustle. She confronts Pierce in his office and throws the law right back in his face. She cites her defense, adverse possession under color of title.
Also known colloquially as squatters' rights. It's a legal doctrine where a person who does not have clear legal title to a piece of property can acquire legal ownership based on continuous, open, and notorious occupation of the land for a specific statutory period.
While paying the property taxes and maintaining the land, right?
Right. She is telling Pierce that even if he produces a paper heir, she has openly occupied and maintained that farm against all other claims for decades, completely nullifying his maneuver.
It is a stunning display of legal combat. But, I mean, you look at the sheer volume of these attacks, the AG, the governor, the tabloids, the predatory lawyers, it creates a suffocating atmosphere.
That feels almost paranoid, right?
Yeah. Like, are we supposed to see this as a coordinated conspiracy or just the reality of blood in the water?
It's the ecosystem of high-profile cases. When the system senses a threat to its equilibrium, antibodies attack the disruption from all directions. Opportunists see blood in the water.
Recognizing that the state establishment is utilizing every lever of power to dictate the outcome, Judge Stone realizes that her only recourse is absolute, unyielding control over the physical and procedural space of her courtroom.
She denies the motions for a change of venue. She forces the trial of State v. Brea Gaines to proceed exactly where it belongs, in the 1871 courthouse in Bullitt County.
And crucially, to protect the integrity of the process, she orders the jury to be fully sequestered.
Sequestration, meaning the jurors are entirely isolated from the outside world for the duration of the trial. They're put up in a hotel, their access to news, internet, and family is severed.
All to prevent the media circus or political pressure from influencing their verdict.
It's a drastic measure, but given the barricades, the National Guard deployments, and the national media park on the courthouse lawn, it's absolutely necessary.
Inside the courtroom, the lines are drawn. The defense is anchored by Benjamin Myers, a high-powered, Duke-educated attorney from Atlanta. He represents the kind of elite, out-of-state legal cavalry brought in for constitutional battles.
Opposite him are D.A. Reeves and A.G. Lindquist, operating as a synchronized, highly aggressive prosecutorial strike team.
The trial begins with voir dire, the process of jury selection. And Judge Stone utilizes a deeply unorthodox psychological tactic to establish trust and maintain control over the panel.
She doesn't remain elevated behind the massive oak bench, does she?
No, she steps down. She walks the center aisle of the gallery in her black robe, placing herself in the exact same physical plane as the prospective jurors.
By breaking the physical barrier of the bench, she humanizes the judicial process. The bench is explicitly designed to project intimidating authority, stepping down project's transparency and shared civic duty.
She speaks to them plainly, explaining that her role is not to please the political apparatus or the media, but to obsessively ensure a fair trial.
She even passes out hard candies from a wicker basket, telling the jurors that she relies on a piece of candy to maintain focus during long testimonies and offering them the same.
It totally disarms the tension in the room. But she balances that warmth with absolute ironclad authority when the decorum of the court is challenged.
Because courtroom decorum is not just about politeness, it is a fundamental requirement for due process. If the gallery is allowed to murmur, protest, or react to testimony, they are subtly influencing the jury.
When a journalist from a local television affiliate speaks out of turn during the proceedings, Judge Stone does not issue a gentle warning.
Oh no. She points directly to the door and expels him immediately, under threat of contempt of court.
She looks at the packed gallery and promises to clear this courtroom with a new broom if there is even a whisper of disruption. She is building a hermetically sealed environment where only the law and the evidence matter.
And the fight over what evidence the jury is allowed to hear begins before the first witness is even sworn in, centering on a highly contentious motion in leaving.
Let's break down the mechanics of this pretrial motion. Benjamin Myers, the defense attorney, uncovers a piece of information that threatens to completely derail the prosecution's case.
He discovers that Starla Jones Nova's abusive mother and a vital witness for the state is having her rent and groceries paid for by Victory Baptist Church.
And the source of that funding is the critical issue here. The pastor of Victory Baptist is Reverend Erskine, the very individual who spearheaded the excommunication of Dr. Bria Gaines from the congregation and has been a vocal public antagonist against her.
So Myers files a motion to completely block Starla and Nova from testifying. He argues a violation of the Brady Rule,
which requires the prosecution to turn over any exculpatory evidence or evidence that could be used to impeach the credibility of a state witness, right?
Exactly. Myers argues that the state's key witnesses are essentially receiving financial compensation bribes, basically from the defendant's primary detractor in exchange for their testimony.
The prosecution vehemently denies any coordination. Naturally, they argue this is simply a church performing its standard charitable duties for a family in poverty and that the state had no knowledge of the arrangement.
This places Judge Stone in a profound judicial bind regarding the admissibility of testimony. And then Reverend Erskine actually appears in court in his clerical collar and attempts to force the judge's hand.
Yeah, he states that if the charity is legally problematic, he will immediately terminate the food and rent assistance to the Jones family.
This is pure emotional blackmail layered over a complex evidentiary ruling. If Judge Stone strictly enforces the defense's request to strike the witnesses, she potentially starves a half-dozen children who rely on that grocery money.
But if she allows the witnesses to testify without addressing the financial arrangement, she deprives Dr. Gaines of her constitutional right to confront her accusers and expose their potential biases to the jury.
By splitting the baby, didn't she just guarantee that everyone in the courtroom is mad at her?
That's exactly what happens. She navigates this by issuing what we can call a King Solomon ruling. She refuses to halt the charitable payments, ensuring the children are fed, and she refuses to strike the witnesses from the docket, allowing the state to present its case. However, she rules that the defense is granted full latitude during cross-examination to bring up every dollar of that church money to question the witness's credibility in front of the jury.
It is a ruling that infuriates both tables. The defense feels they were denied a kill shot to the state's case, and the prosecution is outraged that their witnesses will be painted as paid mercenaries.
But a trial judge's duty is not to build consensus among the lawyers. It is to balance the scales of equity and admissibility. She preserves the welfare of the children while aggressively protecting the defendant's right to cross-examination.
All of the intense legal posturing, the pretrial motions, and the procedural chess matches fall away entirely the moment the human cost of the law is brought to the witness stand.
The prosecution calls their star witness, 13-year-old Nova Jones.
Testifying in open court is a traumatizing experience for adults. For a child who has endured severe abuse, it is agonizing. The text emphasizes Nova's terror. She is so paralyzed by fear that Judge Stone has to gently coax her into the witness box.
Speaking to her with profound care while reminding her of the absolute necessity of telling the truth.
AG Eleanor Lindquist begins the direct examination. Direct examination is typically highly structured and choreographed. Lindquist guides Nova through the timeline of the midnight clinic visit.
The climax of this questioning is the identification. Lindquist asks Nova to look around the courtroom and identify the person who aborted her baby.
Nova points a shaking finger at the defense table and identifies Dr. Bria Gaines. From a prosecutorial standpoint, this is the necessary establishment of fact. The defendant committed the act.
But then, the unpredictable nature of human trauma disrupts the state's pristine narrative.
Without being prompted, Nova turns directly to Judge Stone, crying, and blurts out, "Judge Mary, Dr. Bria was good to me. It's not her fault I got sick. She helped me. She and Nurse Bass both."
Oh, man. D.A. Reeves immediately leaps to his feet, objecting to the unprompted statement and demanding the judge strike it from the record and instruct the jury to disregard it.
Legally, the objection is sustained, but psychologically, the damage to the state's case is profound. The victim of the alleged crime has just openly declared to the jury that the defendant was her savior.
Benjamin Myers senses the vulnerability and stands up for his cross-examination. His goal is to reinforce Nova's desperation to justify Dr. Gaines' actions. He asks Nova a direct, simple question. Do you know who got you pregnant?
Myers is attempting to highlight the tragic circumstances of Nova's life. He expects her to maintain her silence, which would underscore the mystery and terror she was living under.
But the pressure of the courtroom forces a catastrophic rupture. Nova looks out at the packed gallery, her eyes scanning the faces, and the tension simply snaps. She screams, "It could be him. He was there. He raped me."
And she extends her arm, pointing directly into the gallery at a teenage boy wearing a high school fleece.
Mason Phelps.
Yes, the courtroom devolves into absolute pandemonium. The boy, Mason Phelps, attempts to bolt for the doors. Citizens in the gallery physically tackle him.
The bailiffs are shouting, and Judge Stone is forced to violently hammer her gavel, recess the court, and order the sheriff to arrest the boy on the spot.
It is a moment of pure, visceral shock. From a strategic standpoint, the defense team, particularly Benjamin Myers, believes this revelation is the fatal blow to the prosecution.
They assume the jury, having just witnessed a child point out her rapist, will feel overwhelming sympathy for Nova, and by extension, will acquit the doctor who risked everything to rescue her.
Myers underestimates the tactical brilliance and sheer ruthlessness of AG Eleanor Lindquist. When Dr. Bria Gaines takes the stand in her own defense, Lindquist executes a devastating pivot during her cross-examination.
Dr. Gaines' direct testimony is calm and principled. She explains the medical and psychological crisis Nova was in. She explains her ethical obligation as a physician to prevent her patient from bleeding out in a bathroom from a coat hanger.
She frames her actions as a medical necessity. But when Lindquist stands up, she does not engage with the medical data. She does not debate the biology of the abortion.
Right, she bypasses the science entirely and attacks Dr. Gaines on the axis of morality and protective duty. Lindquist asks Dr. Gaines a piercing question. If your primary goal was to help and protect Nova Jones, why didn't you immediately report her sexual abuse to the police?
Dr. Gaines replies that she didn't know the particulars or the identity of the abuser at the time, and this is where Lindquist springs the trap.
She raises her voice, commanding the room, and accuses Dr. Gaines of catastrophic negligence. She argues, instead of calling the police, instead of getting this child into the safety of the state system, you quietly aborted the pregnancy and sent a vulnerable 13-year-old girl right back out into the dark to be raped again by her abuser.
You covered up the evidence of a crime and did absolutely nothing to protect her from future assaults.
It is a masterful, horrific piece of psychological manipulation. Lindquist takes the defense's core argument, Dr. Gaines' profound compassion and desire to protect Nova, and completely weaponizes it.
She reframes the act of the abortion not as a rescue, but as an act of negligent endangerment that facilitated further abuse.
To understand why this is so effective, we really have to look at the psychology of the jury box in that exact moment.
Right, because the jury has just experienced the severe emotional trauma of watching a child point out her rapist. They are flooded with righteous anger and a desperate need for retribution.
But the rapist, Mason Phelps, is not sitting at the defense table. The doctor is. Lindquist seamlessly redirects the jury's fury at the abuser onto the doctor, painting Dr. Gaines as an accomplice to the cycle of abuse through her silence.
But legally, we have to examine how this argument is even permissible in the courtroom.
Yeah, wait, the law they're prosecuting her under doesn't care about rape? The Alabama Human Life Protection Act is ruthlessly explicit. Rape and incest are not exceptions to the abortion ban. The prosecution is trying Dr. Gaines for performing an abortion, full stop. The circumstances of Nova's conception are legally irrelevant under the statute. Why is the prosecution suddenly using the rape to convict her?
You are echoing the exact frantic objection Benjamin Myers makes. He argues that the line of questioning is highly prejudicial and legally irrelevant to the statute at hand.
But Judge Stone overrules it.
Yes, she is forced to overrule the objection based on the rules of evidence, specifically the concept of opening the door.
Meaning the defense brought it upon themselves.
Exactly. The defense team chose to introduce Nova's tragic circumstances and her state of mind to establish a necessity defense for Dr. Gaines.
They argued to the jury, look at the horrific situation this child was in. Dr. Gaines had to act.
Right. And under the rules of evidence, once the defense introduces a theme to justify the defendant's actions, they open the door for the prosecution to test the validity of that justification.
Lindquist is legally permitted to ask, if your actions were justified by a desire to save her, why were your actions so incomplete?
It is legally sound but emotionally devastating. You can physically see the effect on the jury. The narrative observes jurors crossing their arms, their body language shifting away from the defense table.
Lindquist's rhetoric has successfully muddied the waters, turning a clear-cut medical decision into a complex moral failing. The trial concludes, and the fate of Dr. Bria Gaines is handed over to the 12 citizens in the jury room.
And the jury vanishes into deliberations. They deliberate for 2 grueling, agonizing days, which is an absolute eternity in a trial of this nature. It signals profound internal conflict.
The tension in the courthouse is suffocating. Finally, the bailiff hands Judge Stone a note from the jury foreperson. It states unequivocally that the jury is deadlocked. They cannot reach a unanimous verdict. It is a hung jury.
A mistrial due to a hung jury means the state has failed to secure a conviction, but the defendant is not acquitted.
Dr. Gaines would remain under indictment, the specter of prison still hanging over her, and the state would have the option to impanel a new jury and force her to endure the entire ordeal again.
D.A. Reeves, terrified of losing his political slam dunk and unwilling to risk a second trial that might end in acquittal, formally requests that Judge Stone issue the dynamite charge to force a verdict.
The dynamite charge, formerly known in federal courts as an Allen charge, originating from the 1896 Supreme Court case Allen v. United States, is one of the most controversial instructions a judge can give.
It is a supplemental jury instruction urging a deadlocked panel to re-examine their views, listen to the arguments of their peers with a disposition to be convinced, and make every reasonable effort to reach a unanimous verdict.
Why is it so controversial, though? Why do some legal scholars and jurisdictions despise it so much?
Because of the immense psychological pressure it places on the minority holdouts. If you have 10 jurors voting guilty and 2 voting not guilty, the dynamite charge often makes the 2 holdouts feel that the judge, the ultimate authority figure, is subtly ordering them to abandon their convictions.
Like cave to the majority and wrap things up so everyone can go home.
Exactly. It risks coercing a verdict based on exhaustion rather than the actual burden of proof.
Judge Stone is deeply reluctant, but she reads the charge. The jury returns to the deliberation room. Hours pass. Finally, they signal they reach a verdict.
The courtroom holds its collective breath. Judge Stone reads the verdict form. The jury finds Dr. Bria Gaines guilty.
It is a crushing blow, but there is a crucial, telling addendum attached to the verdict form. The jury recommends a sentence of 10 years in prison.
10 years is the absolute statutory minimum sentence allowed under the Class A felony guidelines for this charge, which cap at 99 years or life.
When you see a guilty verdict paired with a plea for the absolute minimum punishment, what does that tell you about the dynamics inside that deliberation room?
It screams of a jury compromise. The deadlock was likely broken not by a sudden realization of overwhelming evidence, but by negotiation born of sheer exhaustion.
You had a faction of jurors who believed Dr. Gaines was justified or morally innocent, holding out against a faction whipped into a frenzy by Lindquist's emotional arguments.
And to end the stalemate, under the pressure of the dynamite charge, the holdouts agreed to vote guilty on the condition that the hardliners agreed to recommend the most lenient sentence possible.
They treated a criminal verdict like a contract negotiation. But the reality is, a 10-year sentence in an Alabama state penitentiary is a destroyed life. Brea's medical license is instantly revoked. Her freedom is gone.
The courtroom erupts in chaos. D.A. Reeves is shouting for her bond to be immediately revoked so she can be taken into custody in handcuffs. Benjamin Myers is physically holding up a shattered Dr. Gaines.
It appears the state's political machinery has triumphed, but they failed to account for the ultimate authority in that room. This is the moment Judge Mary Stone makes the most audacious, legally complex, and consequential decision of her career.
She hammers her gavel to silence the room, she orders the prosecutors to sit down, and then, looking out over the stunned courtroom, she formally invokes Alabama Rule of Criminal Procedure 20.3.
The invocation of Rule 20.3 is the nuclear option of the judicial system. It is a mechanism of immense power that is rarely utilized, precisely because it completely subverts the standard expectations of a jury trial.
We really need to analyze the exact mechanics of this rule. What does it actually allow a judge to do?
Rule 20.3, which governs motions for a judgment of acquittal, allows a presiding judge, after a jury has returned a verdict of guilty, to unilaterally set aside that jury verdict and enter a judgment of acquittal.
The judge essentially overrules the 12 citizens in the box.
Exactly. By invoking it, Judge Stone is legally declaring that, viewing the evidence in the light most favorable to the prosecution, the state fundamentally failed to prove its case beyond a reasonable doubt as a matter of law.
Regardless of the emotional compromise the jury reached.
She looked at the state's case, she looks at Lindquist's psychological manipulation regarding the rape, and she determines that the prosecution failed to legally dismantle the defense's assertion that the abortion was a medical necessity to prevent severe harm.
The jury convicted based on anger, not evidence, so she steps in. She looks at Dr. Brea Gaines and declares her not guilty, effectively telling her she is a free woman.
The ensuing explosion in the courtroom is monumental. The defense table is weeping in jubilation. The press is sprinting for the exits to file their stories. D.A. Reeves and A.G. Lindquist are apoplectic, their career-making victory snatched away in a matter of seconds.
But we must examine the philosophical friction of this ruling. To a layperson, setting aside a jury verdict feels profoundly anti-democratic. The American legal system venerates the jury as the ultimate voice of the community, the conscience of the people.
Setting aside a jury verdict feels like a massive overreach. Isn't Rule 20.3 a dictatorial move by a single, unelected, or politically motivated official?
That is the exact rhetoric her political opponents immediately deploy against her. They frame her as an activist tyrant ignoring the will of the voters. However, the framers of our legal framework understood a critical flaw in the jury system. Juries are composed of human beings.
Human beings are susceptible to exhaustion, prejudice, fear, and the brilliant manipulative rhetoric of skilled lawyers like Eleanor Lindquist.
A jury can literally be whipped into a mob. The judge is positioned as the final, unyielding bulwark of the law against the passions of the majority.
So if a jury convicts a defendant based on emotional rhetoric rather than the strict legal standard of proof beyond a reasonable doubt, the judge has a sworn constitutional duty to intervene and prevent a miscarriage of justice.
It is non-overreach. It is the safety valve of the system functioning exactly as it was designed to prevent the tyranny of an emotional majority.
But Judge Stone understands the personal cost of deploying that safety valve. As she watches Brea Gaines walk out of the courthouse a free woman, Mary accepts that her own judicial career is likely over.
She is facing re-election in November. The state's political machine, furious at being thwarted, goes into absolute overdrive.
They flood the airwaves in Bullock County with attack ads. They portray her as a rogue dictator who coddles criminals and mocks the Christian values of her constituents. They circulate imagery of her wearing a crooked, cartoonish crown.
Cementing the narrative of an out-of-touch monarch.
Anticipating a crushing defeat, she begins packing up her chambers. The stress has already taken a massive physical toll. During the trial, her ancestral farmhouse was literally burned to the ground in an act of targeted arson.
Which is horrific. She is living in a trailer on the property as Election Day arrives. She sits alone, watching the precinct returns roll in from the rural districts of the Black Belt.
And against the overwhelming weight of state money, tabloid smears, and political pressure, the results solidify. Judge Mary Stone wins re-election. The community returns her to the bench.
Which speaks volumes about the electorate of her jurisdiction. The people of Bullitt County, many of whom have generational memories of the law being used as a weapon of suppression, recognize the reality of the system.
They don't want a passive administrator who bows to the governor's office. They recognize that a system capable of railroading a compassionate doctor is capable of railroading anyone.
They respect a judge who possesses the courage to burn her own political capital to the ground to ensure that justice, true equity, is served in her courtroom.
It is a profound validation of her identity. She realizes that her imposter syndrome was a ghost. She belongs on that bench because she is willing to bear the agonizing weight of its true purpose.
This brings us to the conclusion of our deep dive into the world of Judge Stone.
We have traced the incredible trajectory of a rural judge navigating the suffocating pressure of state politics, predatory legal maneuvers, and a deeply traumatized community.
We've seen how the rigid text of a statute can create impossible moral choices, and how the ultimate defense against an overzealous state is a judge who refuses to surrender her courtroom to the loudest voices.
The novel is a brilliant exploration of what is required to wield institutional power ethically when the institution itself is under siege. But we want to leave you, our listener, with a final provocative thought to consider.
The book does not end with a neat cinematic fade to black. It ends with Judge Stone back on the bench in her black robe.
It is a new day, and a new docket is called. The bailiff brings in the next defendant. It is Mason Phelps, the teenage boy who raped Nova Jones.
The machinery of the legal system never halts. The scales must be balanced again.
The docket is eternal. So here's the question we leave you to explore. If a judge's ultimate duty is not merely to the enforcement of statutes, but to the execution of justice, what happens to a society when the strict, codified letter of the law and the emotional will of the jury are fundamentally at odds with what is morally right?
When the gavel finally falls in that 1871 courthouse, who is truly on trial? The desperate individual sitting at the defense table, or the architecture of the legal system itself?
We want the law to be a precise, clean instrument, an equation that always balances.
But the reality is an ocean of muddy waters.
And we survive because we have judges like Mary Stone who are not afraid to wade into the mud. Thank you for joining us on this deep dive. Keep reading, keep questioning the mechanics of the world around you, and we will see you next time.